Well, hello and welcome to this week's video on estate planning. I'm Christopher Nudo and I am an estate planning lawyer in the suburbs of Chicago, serving the Arlington Heights and Elgin communities. And actually, I guess we serve much more than that, but that's where our offices are located. You know, these videos each week are designed to help you understand why the estate planning process is so important for you and your family. Today, we're going to focus on the probate process, estate administration, and living trust administration, what each of those are, what their advantages and disadvantages are, and how each of these can help or be a hindrance to your family. Little background on me. I've been doing estate planning for 30 years now, and I work with families day in and day out through their good times and their sad times. And I've experienced the benefits of a well-planned estate plan, and I have seen the tragedies of people that have waited too long and have not put a plan together. Today, we're going to talk about some aspects of the planning process and what can occur if your estate is planned in two different ways. One way is if it's planned using what's called testamentary transfers, and that is traditionally transfers that happen by a will. And then we're going to also talk about transfers that occur by contract and living trusts, or any trust instrument tend to be a type of contract transfer. So let's start with an overview of the Illinois probate process. When I look back at probate, I see that it goes back almost as long as man has walked this earth, and no, I'm not exaggerating. So what is the probate process before we get into its history? Currently, it's a court proceeding that takes place in the county in which the person died. It is the administrative process that helps transfer property from a deceased person to either their heirs or their legatees. A legatee is somebody who receives a gift through a will, and an heir is somebody who inherits property by manner of law through our laws of intestacy. A lot of big words today. Intestacy, by the way, is the transfer of property without a will. So when somebody passes away and they have property, they no longer have the will or the authority to transfer that property to the people that they love or they intend to. And many people would look at me and say, Chris, that's what my will is for. I designed this will, I signed it. It says I want all of my property to go to my best friends, my wife, my husband, my children, my nieces, my nephews, etc. The problem is that for the authority under that will to be effective, it needs to be admitted to the Illinois probate court system in the county in which the person died. Now, as I started to mention, this process of the government getting involved with the transfer of property when somebody dies can go back all the way to, there are instances of this in the Roman Empire. There are definitely instances of these types of processes in biblical times, going back to before Christ and certainly after Christ. There are lots of instances where England, as it was developing, and long before the United States existed, there were processes when people died. The king would get involved, and he or she, queen, would be involved in the transfer of property. And then as we started developing the United States, while we are unique in our three branches of government, nonetheless, one of our branches of government, the judicial branch, is in charge of helping with the transfer of property when people die. So that was a little overview of the probate process. Let's talk about what the goal of the probate process is. It is designed, first and foremost, to ensure that anybody whom the deceased person owes has a forum in which to get repaid. I like to say very simply that the probate process, first and foremost, is designed to ensure that all of your creditors get a voice with regard to the assets of your estate so that they can be paid for what you owed them prior to your death. Second, the probate process is designed then to administer the transfer of the assets to your heirs and or legatees. Now, there are some elements of the probate process that I do not find appealing. One of them is, here in the Chicagoland area, the probate process is very cumbersome and difficult to navigate, thereby making it very difficult for people to go through this process on their own. They must hire a lawyer to navigate this process, and lawyers can be very expensive. In my experience, the probate process can cost $6,000, $10,000, $12,000, $18,000 or more, depending on the sophistication and the size of the estate. Also, the process is very inefficient, with the average probate lasting at least 12 to 14 months. Also, the probate process or your will cannot help you at all during your lifetime. And that may sound kind of silly, because when people do a will, they do them in anticipation of death. However, what you'll learn is having a trust and some other documents in your estate plan can help during your lifetime, where just having a simple will does not give you any lifetime benefits. Also, this is a very public process, meaning that you are in a court system, and our courts, because they're government institutions, are open to the public. So pre-COVID, you could walk into a courtroom, have a seat in the gallery, and that could be your entertainment for the day, listening to everybody else's business as they come to and from the courtroom with whatever agendas they have that day. Additionally, now that we are in COVID, post-COVID times, a lot of our courts have moved to an online platform such as Zoom. And if any of you have been in a Zoom meeting, you will note that it's like all standing in a circle and everybody talking, hopefully not upon one another, but with no sense of privacy whatsoever. And our court system today are cattle calls of Zoom meetings where certainly everybody hears everybody else's business, and it's all captured right in front of you on your laptop. And so there's no sense of privacy. I like to always say that every family has a weird uncle and a crazy niece. These are the people in your family that are very well intended. They want to give their input into every situation. And so if you have a will and we go to the probate courts, this is an open invitation for that weird uncle and crazy niece to come in and share their views. And their views may be very different than your views as you've left in your will. But because the probate process is this open process, it gives everybody the opportunity to come in and express whether or not what you have designed for your family in your will should or should not occur. So I always like to say that first and foremost, the probate process does not have your heirs, your children, your wife at the first and foremost best interest. The probate process has your creditors and the IRS and us lawyers and the funeral home first and foremost as the most important. So it's my experience that my clients, when they understand that the probate process doesn't put their most loved possession, their family first, they ask me, Chris, how do you avoid this process? And that is an excellent question that we will definitely dive into. So we talked about the fact that probate is a testate transfer of property. And I also mentioned that there are other ways to transfer property if set up appropriately, and that is contract transfers. And the two types of contract transfers that we're going to talk about today are beneficiary transfers and trust transfers, which are beneficiary transfers also. So not to confuse things, but let me just give you examples. Life insurance has a beneficiary on it. And when you pass away, the named beneficiary on the policy gets the death benefit. On your 401k or an IRA or any other type of retirement account, they should have a named beneficiary. When you die, that property gets transferred to the named beneficiary. With a trust, it is exactly the same. If you design a trust, you will say, upon my death, the property controlled by this trust will be paid to a named beneficiary. And when we use these types of contract transfers, beneficiary transfers, they avoid the probate process. So, what are the advantages of avoiding it? Well, as you can imagine, first and foremost, the whole system is private. Because we're not in the local court system, we can now dictate who is entitled to input and who is entitled to information. Let's go back to our weird uncle, and our crazy niece. You pass away, leaving all of your property to your children and Fluffy the dog. And your brother, your weird uncle, and your crazy niece say to your children, by the way, we have lots to tell you about your deceased parents, and we don't think the way they left their estate is proper. As a matter of fact, before they died, they told us this is the way they want the estate handled. The problem with that is the trust document that your parents left behind does not fall in line or does not match what the weird uncle and crazy niece have to say. And so the private nature of a trust will permit the weird uncle and crazy niece to be barred from any input into the estate administration. Let me say this more clearly. Only the people named in a trust as either beneficiaries or trustees are entitled to get the information as to the terms of the trust. So you can simply tell our weird uncle and crazy niece, I'm sorry, but my parents did not leave a job for you or didn't leave you as a beneficiary under their trust. So your input is not welcome. And that is very comforting to many people because that private nature and that ability for others not to influence a trust or its administration gives a lot of people much comfort, and that's why trusts are very popular. Additionally, a trust has your family usually first and foremost as the priority. A trust definitely has your beneficiaries first and foremost. So as long as your beneficiaries are your family, then my previous statement is true. But unlike the probate process that puts your creditors first and everybody else, trust administration, while certainly needing to address the issue of paying your debts and creditors and taxes and anything else, while all of those things being very paramount in a good trust administration, the trust is truly designed for the beneficiaries. And those are your loved ones that you have designed the trust to benefit after you have died. Now, a trust administration is a very efficient process compared to the probate process. First of all, the average trust administration takes about 3 to 5 months versus 12 to 14 months of the probate process. It also is relatively inexpensive. I mentioned the fact that probate could be $6,000, $10,000, $12,000, $18,000 or more. Most trust administration costs are somewhere from $500 to $2,000, depending on how much assistance the trustee might need through the administrative process. Attorneys are not needed anywhere near as much in the trust administration process. It is a very logical and common sense process. And so what I've learned over these years is that when somebody passes away, the successor trustee under their trust will come to me for some guidance as to what the terms of the trust say and how they should administer those trust terms for the benefit of your beneficiaries. But once they understand the process, then they usually do not need any further assistance from my office. And that is a very positive thing for most families, since they have left their assets to their heirs, their beneficiaries, and they didn't leave them to me as a lawyer. And so the less they need to hire a law firm to help in this process, the more that there's available for the family, and that makes for a happy client. So, unfortunately, there are many times when people pass away and it's a tragic passing and they leave minor children. And when this occurs, there's lots of considerations that need to be thought through. Number one is, who's going to raise the children? And that is a guardianship question. The second question is, how is any money which might be left over from the deceased parents going to be administered for those minor children? And who is going to administer it, and who is going to make sure that that money is used for the best interest of those minor children? The probate process does not by any means have an efficient way to deal with those questions. The trust process has great ways to deal with those questions. So I always tell my young couples that have young children, designing your trust for the tragic occurrence of both parents dying and putting together what we call children's trusts that would properly administer the assets of the parents for the benefit of their children while they are minors and into adulthood is a very good process. This will ensure that the money is used for keeping the children in as much of a lifestyle that they're accustomed to as can be permitted. Additionally, we can control distributions to the children. If I inherited 6 figures worth of money when I was 18 years old, I may have done something dumb, like purchased a car that was not a good use of the money long term. Why is that? Well, because people younger in age do not have the foresight to understand that money spent wisely that lasts for many more years will be far more effective for them over their lifetime than buying a flashy new sports car. So in our trust design processes, we tend to design children's trusts with children being defined as minors all the way up until age 25. And why do we use age 25? Well, because that is an age where most boys and girls, men and women, tend to have a greater change in their maturity level between as they advance in years. Now, does that mean that at age 25 we give them all of the trust assets of their deceased parents? And the answer is typically not. We'll set aside some form of stage distribution where the children would get a small amount of the trust assets, maybe 1/3 of the assets at age 25, 1/3 at age 30, and 1/3 at age 35, just as an example. Many of these decisions really depend on the age of the children and the size of the state. So we've kind of talked about what is the trust administration process, and that is organizing the trust assets in such a way that they can be efficiently administered for the best interest of your beneficiaries, who are typically your spouse and your children. Oh, and don't forget the dog, because everybody today seems to want to make provision for Max the dog. So who should you choose to be your trustee? This is the person that will be in charge of the trust and will be in charge of taking the assets that you have accumulated and best organizing them and administering them for the benefit of your children. I always recommend that if you have minor children, this should be somebody who you would trust with your bank accounts, because this person is going to take your valuable hard-earned assets and they are going to work with a financial advisor to invest those assets in the best possible way to ensure that there's money available to pay for your children's expenses. And we know that, dance lessons, soccer, basketball, football, guitar lessons, private schooling, college, a car, a wedding, all of these things are very expensive. And you want somebody who's going to be very trustworthy, who will properly manage the money to ensure the maximum benefit to your children. Also, this person should be very trustworthy in that they will not be tempted to use this money inappropriately. And so we want this person to only have your children as their best interest. Now, if you are older and your children are in their late 20s, 30s, and above, it's very common that you would just name your children as the trustees of their own trust, because they're at an age that when their parents die, not only the benefit of the assets will transfer to the children, but also the children will have control of those assets. This creates an extremely efficient model for estate transfers. And as you can imagine, the avoidance of probate here and all of the unneeded bureaucracy of the process, time and expense is avoided when simply using the living trust. So, what to expect when working with an estate planning attorney? Well, you can expect that first and foremost, we are going to want to understand you. What a good estate planning attorney's job is to understand, number one, what does your estate look like? How much real estate do you own? Retirement accounts, life insurance, and other assets. Maybe you're an avid collector of baseball cards, or I always loved back in the day the beer can collection. Whatever your asset mix looks like, it's very important that an estate planning attorney take the time and understand that. And the second thing is to understand what's important to you when you die. What do you want to keep your children in the same type of lifestyle that they've become accustomed to? Do you want to leave money to others in addition to your children? Many of my clients are very philanthropic. So organizations like World Vision or their church or Anti-Cruelty Society, just to name a few, are very common dispositions of people's estate in addition to their children. So it's understanding the client and what's important to them is the next most important thing you should seek out in a good estate planning attorney. And then finally, the estate planning attorney should take the time and explain to you what documents best are suited to accomplish the goals that you've just set forth for when you die for your family. And it's very important that that the attorney explain to you each document and why it's used, so that you have an appreciation for the plan they put together. Estate planning, for the most part, is not inexpensive. Estate planning processes that include trust can start at $2,600 and go way up into the multiples of thousands, depending on the sophistication and size of the estate. And so when you're spending this kind of money for your family, it's very important that the package of documents that you receive in a good estate plan, you understand, so you can value the job that the attorney did for you. When a good estate planning attorney goes through each one of these steps, understanding your assets, your values, and the documents that are going to be designed for your estate plan, then you will have a great deal of confidence that the plan that was designed will do what you set forth to get accomplished. So let's take a couple minutes now and recap for those of you who are joining us a little later in this podcast. My name is Christopher Nudo. I am the founding partner of an estate planning attorney at an estate planning law firm, and I'm also a real estate lawyer, and we have offices in Arlington Heights, Illinois, and Elgin, Illinois. I am a very faith-based person, belonging to non-denominational evangelical church, and have a firm foundation in the biblical truths and in Jesus Christ. I am not ashamed of these things, and it's been my experience that it is the grounding in my faith that gives me the ability to have the necessary empathy towards my client base, and to listen and value what is important to them, and to put their needs first to ensure that I can do the best job I can based on the gifts the Lord has given me. So we have covered today what you need to know about the probate process, and why designated trust administration is so important. And by the way, if you've missed some of my previous videos on how to legally protect your assets if you become incapacitated, you can find them right here and give those a watch. We welcome you here every Friday, 8 a.m. Central Time, where we can share different legal tips and guidance on estate planning and real estate. I've noticed that many of you have submitted quite a few questions today. So while we still have a little bit of time, I'd like to dive into those questions before we wrap up. So let's see if we can get all through these quickly and in an efficient manner. Oh, here we go. What are my options for dealing with a family member's assets stuck in probate? Oh, that is so common. So many people feel that their estates, family members' estates, get stuck in the probate process. It's probably not stuck. It's just that the probate process is so incredibly slow and cumbersome that it feels like it's stuck. Think about trying to run in quicksand. You're using a lot of energy, but not going anywhere. And the probate process today feels a little bit like that. So my recommendation is to get with the lawyer who is helping with the probate estate. sit down with them, understand from them at what stage of the process the probate is in, and ask them to explain a timeline of and to give you a realistic expectation as to getting those assets from the probate to their intended people. Great question. Thank you. Next question. What is the cost of basic legal documents to avoid the probate process? Great question. I touched on that just recently. To avoid the basic probate process really depends on the type of assets you have in your estate. It could be as little as $1,000 for just some basic powers of attorney and some guidance into some beneficiary designations. But most common, the cost is the implementation of some sort of trust plan. And like I mentioned, trust plans range in price, with the low end tending to be around $2,600 and then going up to the many thousands. I would say the average family here in the city of Chicago and surrounding suburbs pays somewhere between $3,500 and $5,000 for a comprehensive way to plan their estate in which to avoid the probate process. Question number 3. These are really good questions, by the way, and I really appreciate your participation. It helps me help you. Do I have to have a trust if I am not married with no children? Great question. The answer is, it depends. So you're not married and you don't have any children, but guess what? You have a lot of assets. You have a lot of money in your 401k. You have at least one house. You have a car. You have a boat. You have lots of things. So what are you going to do with them? Who are they going to go to? You know, people like this most definitely should have a trust so that we can ensure that when they die, the people who are important to them, and since they don't have a spouse and children, it can be friends, it can be neighbors, it can be nieces, nephews, it can be siblings. We want to make sure all of these important people in their lives are identified and that we can get your assets to them with them not having to go through the probate process. So great question, and the answer is usually a resounding yes. All right, our next question. How can I prevent my trust administration from selling my assets or disregarding my wishes? Excellent question. This is where the concept of fiduciary comes in. If you're not familiar with the term fiduciary, Google it. But the bottom line is a fiduciary is somebody who is legally obligated to act in the best interest of somebody else. And when you are the trustee of a trust, it is very important that you act in the very best interest of the beneficiaries under the trust. If you're the executor of a will and the will is being probated, you have to act in the very best interest of the legatees under that will. Both of these jobs are fiduciary positions, meaning the law dictates that if you do not act in the best interest of the people who you're there to serve, you will be held personally accountable. So, knowing the importance and the consequences of being a bad actor usually stops people from disregarding your intent and your wishes. Not to mention the fact that if the trustee or executor does disregard them, there are severe consequences, and including jail time under certain circumstances. So it is the concept of a fiduciary obligation that is the check and balance to ensure that your executor and trustee do the right things. How long after you pass away does the state take control of your property? Love that question. So the state does not ever really take control of your property. Now, can they? The answer is yes, in certain instances. But in Illinois, at the very least, all the state would do is try and find somebody in your family or your friend base who will help them get involved for the orderly administration of your estate. It's not like the old days where when you died, the king would come in or the king would send his people over to your house and would say, all right, let's get busy and take care of this. It's not like that anymore. There used to be the phrase, it's good to be the king. Well, I still think it is good to be the king, but we don't have kings here in the United States. So, and not in Illinois. Well, at least we don't have people in Illinois that hold the title of king. And so the state's not going to come in and take control of the estate. But in abandoned estates, the state will try and get involved just to help with the find some order amidst the chaos and help distribute the assets to whomever assets are entitled to, usually using the laws of intestacy as described earlier in this message. By the way, this is totally a random thought, but with regard to intestacy, I found it very interesting in the Bible, Numbers chapter 27, 1 through 11, specifically paragraph 8, describes the transfer of property through a family. And that is the first known written representation of the transfer of property between family members that I know. And here in Illinois, the procedure outlined in the Bible under Numbers chapter 27, paragraph 8, is also exactly what Illinois' law of intestacy transfers mirrors. And I just find that very fascinating. So sorry for that tangent. Let's get back to our questions. What would happen if I create a will online and I did it wrong? Well, I chuckle and I shouldn't, because that's actually a very tragic occurrence that would occur. So you create your, I call this your do-it-yourself attorney. I understand why people like to do things that way. They do it because it's cheaper. But if you do it wrong, then after you have passed away and we find out that the will was done wrong, then the will becomes ineffective, and it's if you died without a will. And that can have significant repercussions upon your estate, depending on how you set forth your wishes in your will. If your will is set aside and disregarded, all of your wishes could be disregarded also. Next question. What if I have a limited budget? What documents should I have prepared first? I believe that some of the most important documents are powers of attorney for healthcare and powers of attorney for property. Many people suffer from dementia later in life as due to some form of illness or a stroke of some kind, and can even be part of an accident in younger folks. And so planning for an incapacity is something every family should do. I believe this should be done as early as age 18 in adults, because when somebody becomes disabled, it's too late to do this planning. So the most important documents to get done initially are powers of attorney for healthcare and property, but then quickly making sure you have a will and or a trust, depending on the complexity and the size of your estate, and advice from a good estate planning lawyer, though this is the order in which these things should be reviewed. Thank you for that question. That was an excellent one. Do I offer virtual appointments or on-site visits? Well, why can't I do both? So yes, I do a lot of virtual consultations. I like to keep these high level and go through the first part of what I suggested earlier, which is I use those video consults to really learn about you, your estate, and your values. And then I give you a price for the documents that I'm going to prepare. And if it sounds like I've provided you with good value, then we move to the next step, which is planning for how your documents will be prepared. And that can be a one-step or two-step process. And I do it in person and virtually all day long. So thank you for that question. So finally, many people want to know, where can they contact me and set up a consultation? So you can call me right here. Look at this. You can call or text me, and we would be happy to set up that in-person or virtual consultation. Under certain circumstances, I run into people who cannot get out of their home because they're not mobile. And under very special circumstances, we will even travel to your home and meet with you if mobility and technology are an issue. So I want to really thank everybody for the questions. I'm always blown away each week at the insight and thoughtfulness that come from our viewers. And I cherish this opportunity to earn your trust and work with you and plan for your family's estate. And like anything in life, proper estate planning process takes a little bit of time. The average time frame is about 4 weeks from beginning to end. I encourage you to reach out to us and just start a discussion. And it would be my pleasure to discuss your family's goals and values and translate that down into a comprehensive plan to ensure that upon your passing, your loved ones are most cared for. I invite you to join me here again next week on our Facebook Live. I think it's Fridays at 10:30 Central Time that we're making this happen, and I wish you would join me at that time. And please feel free to invite your family and your friends. Share this recording. That would be a huge blessing to me. Your parents might want to listen to it, some friends, neighbors, other colleagues, and I really, really look forward to seeing you here back next week, same time. You have an absolutely blessed week. Thank you.